Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am a corporate lawyer. Today we will discuss Section 7 of Prevention of Corruption Act with the help of suitable examples so that we could understand even our case in practical way. If you want to enhance your knowledge or information on the subject, I request all of you to maintain a proper notebook and please note down the points accordingly. Section 7 of PC Act inter alia comes into motion when we are having a trap case or a case against a public servant which is based only on demand. Section 7 title clearly spells that offense relating to public servant being bribed. So basically it is concerned with undue advantage. To be noted that undue advantage cannot be a sole criteria to decide the fate of Section 7 of PC Act. To apply Section 7 of PC Act, the primary condition is that the accused must be a public servant. If the accused is not a public servant, in that scenario, he could not be prosecuted as per Section 7 of PC Act. And apart from that, we have to study clause number A, B and C to enhance our information on the subject more effectively. Clause number A says, if the public servant obtains or accepts or attempt to obtain. There is a difference between obtain and acceptance. To understand that concept, we have to study the important judgment of Honorable Supreme Court, that is Neeraj versus State of NCT. Judgment date is 15th of December 2022. In that case, it is observed that Section 7 of PC Act would be applicable only when the public servant inter alia accepts the offer of concerned complainant regarding undue advantage, but the acceptance must be voluntarily. If the acceptance is not voluntarily, in that scenario he could not be prosecuted. Apart from that, we are having multiple judgments of Honorable Supreme Court on said point. As far as obtain is concerned, it is basically a demand on the part of public servant with element of acceptance. An attempt is concerned with demand only, not with acceptance. So, to apply Section 7A of PC Act, there must be an element on record that the concerned public servant either obtains or accepts or attempt to obtain from any person an undue advantage. Undue advantage means illegal gratification, and it must be in consideration. If it is in kind, in that scenario Section 11 of PC Act would be applicable. Apart from that, the key element is that there must be an intention of the public servant behind the same. An intention can be find out on the basis of overt or conduct of public servant. For example, if it is a case of Anti-Corruption Bureau that the concerned public servant is willing to accept the bribe, but there is no phone call on the part of accused, rather than there is a constant call on the part of complainant. In that scenario, the conduct could be ascertained, and on the basis of which the intention could be ascertained, for which Section 8 of Indian Evidence Act would be relevant. Apart from that, there must be a requirement of pendency of work, which is called a public duty. So, the said connections must be inter alia connected with performance or cause performance of a public duty, either improperly or dishonestly, which include forbearance or cause forbearance as well. To be noted that we are having an important judgment of Honorable Jharkhand High Court on that point. Judgment name is Pramod versus State of Jharkhand. Judgment date is 16th of November 2022. In that case, it is observed that if there is no pendency of work, in that scenario, it could not be said that there is any motive on the part of concerned accused. to demand and to accept the alleged undue advantage. In that case, on that count, Honorable High Court discharged the accused accordingly. Apart from that, to be noted that the act of the concerned public servant must indicate that he is performing or inter alia cause performance of public duty improperly or dishonestly, which includes forbearance as well. To understand the said legal perspective, we are going to take two examples. Example number 1, which is for performance of a public duty. For example, Mr. A comes to Mr. B. Sir, please install an electronic meter at my home. Mr. B says, I will do the same, but you have to pay me rupees 500 privately. In that scenario, Mr. B would be liable as per section 7 subclause A of PC Act, because inter alia he obtains undue advantage with intention to perform the public duty improperly or dishonestly. As far as forbearance is concerned, to understand the same, we are taking another example. Mr. A says to Mr. B, Sir, please drop the proceeding of outstanding which is issued by department. The outstanding as per notice is rupees 1 crore. I am ready and willing to pay rupees 5 lakh for the same. If the notice is dropped, in that scenario, Mr. B would be liable as per section 7 subclause A of PC Act under the following headings: accepts undue advantage with intention to forbear the performance of public duty improperly or dishonestly. Ultimately, revenue loss had been caused to department due to such forbearance. It is immaterial. The said function can be done by public servant himself, or he may cause another public servant to do the same. As far as clause number B is concerned, there is no change in verbatim, but there is an addition of word as a reward, which means a motive. If the crime is done for certain motive, which is nothing but an undue advantage, in that scenario, section 7b would be applicable, and motive would be indication of the grade of the concerned public servant, and ultimately it would be the indication of intention, and the same can be considered in the light of conduct and overact of the concerned public servant, for which section 8 of Indian Evidence Act would be relevant. As far as section 7c is concerned, it is having the same verbatim, and this time there is addition of two important words: in anticipation of undue advantage or in consequence of acceptance of undue advantage. So when the concerned public servant, either himself or through another public servant, perform or cause performance of a public duty dishonestly or improperly, which include forbearance, and the same is done in anticipation of undue advantage or in consequence of acceptance of undue advantage, in that scenario the public servant or the concerned public servant who is hand in glove with that public servant would be responsible. Now it is clear to us, to apply section 7 of PC Act, the prosecution must satisfy certain conditions. Number 1, there is a requirement of demand. If there is no demand, even though there is recovery or mere acceptance, in that scenario section 7 of PC Act would not be applicable. Number 2, there is a requirement of pendency of work, which is called public duty. And apart from that, the act of concerned public servant must indicate that he is about to perform the said public duty improperly or dishonestly for an undue advantage, which includes the acceptance of undue advantage as a rebut or motive. And further, there might be a case regarding the anticipation of undue advantage, which includes in consequence of acceptance of undue advantage. If all the parameters are satisfied in that scenario, public servant might be responsible, otherwise not. Now the primary question arises how to find out the demand. For this we have to study the report, number 2 FIR, number 3 verification report, number 4 transcription of verification. If there is a mismatch in the theories and apart from that there are inconsistency, then we may have the benefit of judgment of Honorable Karnataka High Court titled as Mahesh PS versus State of Karnataka. Judgment date is 24th of May 2023. So these are the important points to be kept in mind by all of us, so that whenever we are going to study our case, we may formulate multiple questions before initiating. This is called review of the case. For this, we have to study the report and have to find out whether there is any pendency of work or not. If there is no pendency, then may tick the column cross. Apart from that, we have to consider the point of competency of work. Apart from that, we have to work out how many times demand was made or there is voluntarily acceptance to the said offer. In that connection, section 8 of PC Act is specifically emphasizing this time on proviso is quite important, which says that the report must be made within 7 days from cause of action. So on all these points, we could have a proper defense strategy, and by reviewing the case in the proper perspective, we could find out how to proceed and what will be our defense to strike out the concerned prosecution. In the last, I want to add two important points for your information. To be noted that for the application of section 7, there is a requirement of section 17A of PC Act also, because if the concerned public servant is not caught red-handed, in that scenario, the approval of department is sine qua non before inquiry or investigation. The judgment of Honorable Rajasthan High Court named as Rani Dhahan versus State of Rajasthan, judgment date is 8th of October 2024 is important. And apart from that, we have to emphasize that the concerned authority must be competent to investigate as per section 17 of PC Act. For this, we may peruse the judgment of Honorable Supreme Court titled as Vakil Prasad versus State of Bihar. Judgment date is 23rd of Jan 2009. Apart from that, a valid sanction is required as per section 19 subclause 1 of PC Act. For this, you may peruse the judgment of Honorable Supreme Court CBI versus Ashok Kumar Agarwal. Judgment date is 31st of October 2013. And we have to be very much clear on the point that there is a presumption of guilt against us as per section 20 of PC Act. Because if the concerned prosecution totally succeeded to prove the primary elements, means demand, recovery, acceptance, in that scenario, it will be presumed that we have done the crime deliberately. And we have to prove the facts on contrary basis. If we are not succeeded in doing the same in that scenario, we might be convicted. And apart from that, we have to give the explanation of recovery. Failure to do the same might attract adverse inference as per section 119 of Bharatiya Sakshya Adhiniyam, which is equivalent to section 114 subclause G of Indian Evidence Act. But for doing the same, it is not required from us to prove our defense beyond reasonable doubt. We can do so while acting on theory of probable defense. We have to raise a possibility to cause a suspect on the case of prosecution. For example, if the money is recovered from your person, you may take a defense that the money is inter alia thrusted by the concerned complainant. In the meanwhile, team had come and we were compelled to pick up the currency notes and to count the same. And the sad scenario is the possible explanation of the fact that during that process, the concerned currency note had come into the touch of our hands, and that's why the phenolphthalein test was positive. So, by having such defense, we could be succeeded. But what defense is to be taken? It depends upon facts and circumstances. So, defense is to be taken at the earlier stage, and that's why it is usually advised to submit the representation. But there is a theory in your mind that if you are doing the same in that scenario, could have a negative impact on our case. He could cure the defects in the case as well, but to be noted that every prosecution has a story. If a story is set up in inter alia, there is a FIR in that scenario. The story could not be changed. So if we are going to submit our representation and the facts of defense are not considered by the concerned authority in that scenario, we may take the advantage of unfair investigation theory, which is recognized even by Honorable Supreme Court, and the same is part and parcel of Article 21 of Constitution of India. So all these points are to be kept by us in our mind while contesting a false case under Section 7 of PC Act. See you in the next video. Till then, Jai Hind, Jai Bharat.